Okay, Emily, I guess you can start.
Okay. Hi, good afternoon, everyone. Thanks for joining. We're excited to have you all again. We know that not everyone probably had a chance to read over everything, but we're excited to kind of go over some of the materials that have been created and continue our discussion and get some feedback from everyone. Yeah, any comments from last time or anything that people wanted to chime in before we get started?
Jennifer, do you have anything to open with or?
No, I just wanted to say I'm really grateful for everybody, taking the time out of your day. I know everybody's really busy, but this is a very important topic. And I know this is a kind of a hot topic in the workshops that I'm doing with families across the state. So this is time is being put to good use, but I do appreciate everybody for taking the time to participate in this.
Okay, what I thought I would do today is to do a screen share here. And let me see what we have. There we go. Okay, so I'm putting up here the web page for the work group. And on the web page, we have a place for meeting agendas. So I'm going to click on that. And this shows the various meetings that have occurred, are occurring, and will occur. And so the last meeting was focused on what I call the substance, who and what of medical decision making. And there was a document that was sent out to everyone about the basics of medical decision making. And I got some feedback on that and made some revisions based on the feedback. This meeting is getting more in with that in mind, with the basics in mind. This meeting is focusing more on practical aspects of how to utilize the basics or implement the basics in real life. And in a second, I'll click on the link, and then we can go through some of the materials. And at the end of each document, we can open it up for any discussion or comments that people may have about that particular document. The March meeting is going to focus on transitioning youth with who have intellectual or developmental disabilities, and we'll be focusing on some resources that are available, but also I've just finished a commentary that I'll be sending out, but it's available right now on the website. If you were to click on the link for commentary, and it's about the inclusion of medical rights and medical decision making in the transition process for IEPs and ISPs. So we'll be dealing with that in March. In April, we'll be looking at the inclusion of the IDD patient population in the schools for nursing, medicine, dentistry, et cetera, as in their curricula or their clinical programs. And then also continuing education for professionals in practice, and looking at the extent to which IDD issues in patient population are or have been included in continuing education programs. And I've put a lot of feelers out to people on the work group to give me information and feedback about that. And if you were to click on the link for April, you'll see what I've been able to gather so far and where the gaps are in that. And then May will be discussing recommendations, soliciting them from you, and I'll have some, and the other coordinators will have some for us to consider to kind of improve policies and practices in this regard. And then June, we'll be talking about some type of a report with findings and recommendations. So that's where we're headed. So today we're taking a look at the documents that have been produced for dealing with how-to materials. So we have how-to guidance for patients, guidance for families, for providers, and then a longer document that includes references, legal and other reference materials that are relevant to the first three documents. The first three are intended to be more easy to read and follow and so on without all these citations and so on. But all the backup material is for everything that's stated in these other three are contained in the reference document. And then finally there's some sample medical authorization forms that people can consider using or distributing and so on. So anyway, we'll start with the guidance for patients, and then we'll open it up for conversation about that. So the idea of this is to have it probably can be even in more simple language. So this can be improved, of course, to make it more understandable. It could be put in Braille. It could be put on audio in different formats for people, and just to try and make it as easy as possible for patients to read about their rights. And each of the documents has this opening paragraph that refers people to the memo that has the reference materials. So basically, it's letting patients know that they have the right to make their own healthcare decisions once they turn 18, and unless it's taken away by a court. So it's just a heads up. You have the right to make your own medical decisions, unless there's an exception that applies. You have the right to a support person. You have the right to have someone help you make medical decisions, and that's really a part of the Americans with Disabilities Act. Just like anybody has the right to have supports or services provided or allowed to assist them in participating in any service or program. Well, medical services, this applies to medical services too. And one of the forms documents actually has a form where a person could sign something and designate the person they want or persons to be a support person. So also patients have the right to extra help. This is also kind of in conformity with the Americans with Disabilities Act, that you may need, besides having a support person to help you, you may need a sign language interpreter, or you might need someone to read information to you from forms or otherwise. You might need images rather than words. You might need extra time. You might have to have appointments scheduled at a particular time of day that you're functioning at your best. So there's, extra help is something that the person has a right to, and they should know that. Also, they can sign a supported decision-making agreement if they want to formalize the support they're going to be getting from one or more persons. Some of these forms include a whole variety of aspects of life, but medical or healthcare is one of them. And if someone wanted to, they could adapt a supported decision-making agreement form just to include medical and medical only, and to use that particular form just when they're dealing with medical providers, or they could use one of the more standardized forms and that has medical just as a part of any number of areas where there's going to be support provided by someone to help the individual make their own decisions. Also, the fifth here is that the patient can name someone to make medical decisions for them. So this, we're talking about basically a power of attorney for healthcare, or the designation of a patient representative in terms of access to medical records. And so the power of attorney form only kicks in if the patient lacks capacity to make a particular medical decision. If they have capacity, then you're not going to rely on the power of attorney form. You're just going to rely on a supportive decision-making agreement or just the designation of someone as a support person. But in the event that they can't, that medical personnel decide that they believe, have a reasonable belief that the person lacks capacity to make their own medical decisions in a particular, for a particular procedure, for whatever reason, then that's when the medical power of attorney would kick in. That's been previously executed by the individual. And then patients have the right to complain if their rights are violated. So if they feel that their right to make the right to self-determination to make their own decisions is being unjustly violated, or that there's disability discrimination going on, or they're not getting, their support person isn't allowed in the room with them, or the hospital or other provider is saying you don't have capacity, but they feel they do have capacity, they can, complain. And so this kind of gives them information about, they can ask to see a supervisor, then it can go up the chain of command, they can file up more formal grievance. They have the right to have someone help them with the complaint process if they can't do it themselves. And they also can, go to an organization such as Missouri Protection and Advocacy to ask for legal assistance in filing a complaint or a grievance or something with a professional association or with the Bureau of Hospital Standards, et cetera. And then the final is for those who are in a guardianship, which is the minority of this patient population, but it's a significant number. So for those who are in a guardianship, this is to alert them that they have the right to ask to have their medical decision-making rights returned to them. They can either petition to terminate the guardianship or to just have that one area of decision-making, have that right returned to them. And so there's information on that. And then finally, in the area of neglect, if they feel that their medical needs are not being taken care of, or that's for some reason they're a victim of abuse, that they have the right to file a complaint for abuse or neglect. And there's information provided on who to contact and how to do that. So basically, this is the a how-to guide for patients with developmental disabilities. And as I say, this could be simplified more, or larger print, or more visuals, or in any number of ways, but it's a starting point. So at this point, I'd like to open it up to see if there's any comments or feedback on this particular guidance document.
Tom, this is Crystal from Adair County, and I really appreciate your comments about simplifying it a little bit. And I keep thinking about DB 101 videos that talk about benefit videos that are so easy to understand and probably helpful for people who don't have that level of reading skill. So I'm sure that that comes with a cost, but just wanted to throw that out there as those animated explanatory type videos might be a great approach for helping get the word out as well.
Great. That sounds perfect.
That's a
Bring
good
on the money.
idea. Those videos are awesome.
Yeah, just need someone to do it and then the money to do it. But at least this is a starting point. If anyone comes up with, before we finalize everything at the end and the work group comes to a completion in a few months, if you have any other suggestions or ideas of things that should be added or modifications, this is all open to revision at any point.
There's a couple things in the chat. One is about kind of language, and I think just at one point there's a reference to somebody's illness, although I think the context might be important, just making sure that we're specifying illness versus diagnosis or disability when appropriate. The only place I remember seeing illness was in the study, like in the situation of an acute change, so that may be appropriate, but just verifying that that's consistent throughout. And then yeah, I agree that even a simpler version could be helpful. And the only other thing I would say is, like, if this is for patients, I would consider if we should kind of change the language to be like, instead of a patient, like you, and like have this be very patient directed and speak as though you're like addressing the patient.
Yeah, that's a good idea. So this version is kind of more generic, just for everybody, but I agree with you. If this is going to be like a brochure with, graphics and visuals and easy to read, and it's for the patient, then the whole thing would be you're right, and so on, and rather than patient. So I agree with that, change in terminology, and that's an easy fix. Okay, we go back to now the second one, guidance for families. So basically it's following a similar format, but it's directed toward parents or other family members. And it could be any support person actually, but probably families are the more likely ones to be like an immediate advocate for the individual. So this just explains that the family member can be a healthcare supporter, just like the individual can ask for a supporter. The family member can be the supporter if they're the chosen one from the patient. So it's a similar thought, but just put in terms of the family member knowing that they don't really have a right to do it. The patient has the right, the individual has the right, but they can serve in that role. They also can have access to medical information if the adult patient, gives them permission and designates them as the person and probably signs a HIPAA waiver to overcome any confidentiality issues. Of course, all of these designations and authorizations and so on would be signed by the individual with the disability after they become 18. And they can always ask for support prior to that, but in terms of having the legal right to, do waivers and so on, we're talking about adult patients here. And that the family member can be designated to make decisions, so that if the adult patient wants them to serve in that role at a time when a provider finds that the patient lacks capacity at that particular time or under those particular circumstances, that they can fulfill that function. And when capacity exists, then the delegation of authority is no longer valid. It's just valid at times, which might come and go, depending on the situation of the individual. A family member can help a patient fill out documents. So the individual with a disability doesn't have to do everything on their own. They can have somebody, help them, especially with the forms that we'll talk about a little later. A family member can help the patient challenge the denial of rights. So the family member is not really the complaining party because it's not their rights that are being violated. It's the rights of the adult patient that are at issue. And if the adult patient's rights are being violated, then generally it's the patient that would be filing the complaint. However, some patients may lack the ability to file a complaint on their own and may need assistance. And to file a complaint, I mean, we're not talking about going in court and representing someone in court. You can't represent someone in court unless you're a licensed attorney. But if you're outside of court and there's no litigation filed, a family member can assist in helping someone file a complaint to challenge the denial of the patient's rights. So we just list the various ways, and it's always best to, start with the least, don't make a federal case out of something in the first instance. So you ask to speak with a supervisor and then file a formal grievance or file a complaint with the DHSS or the Office of Civil Rights of the United States Department of Health and Human Services, or with licensing agencies that license various professionals. And the family member could also be the one to contact Missouri Protection and Advocacy in the event that the patient himself or herself is not able to do that. Again, P&A would be representing the patient, not the family member, and they would make their own determination as to whether that's appropriate and if they have the resources or are able to do that. And then a family member can help a patient end or change a guardianship. And it's, people are intimidated by courts, but I'm looking at, especially the reference document, there's more details about this, but it can just be a letter to the court. They don't have to be filing formal pleadings. A person doesn't have to be represented by an attorney. So somebody that feels that there's that change in the guardianship or a termination of the guardianship is appropriate, and if the individual themselves who are protected by the guardianship wants to do it, then the individual can file a request with the court, but also a family member can just send a letter to the court and just follow the procedure that's set forth in the statute. They can have an attorney, but they don't have to have an attorney to do that. And then also family members can report medical neglect or abuse. So if they feel that the loved one is not receiving the necessary health care they need, or if the guardian is neglecting them, they can file a complaint with Adult Protective Services, and that would initiate a process of investigation and so on. So this is the how-to for families. Again, things could be, put in terms of you can do this and you can do that. We can change the terminology to make it like a direct conversation with the family member. Anyway, any comments about this document?
Is this the appropriate place to encourage family members to keep an electronic version of, say, supported decision-making agreements or MPOAs or something that they can share with healthcare providers, primaries, hospitals to keep on file so that they don't have to continuously advocate, that it's just a matter of record.
Yeah, that's probably a very good addition. So let me make that note.
I mean, I know, for example, I'm medical POA for my elderly father who has a lot of healthcare decisions, and I keep a PDF copy of that MPOA on my phone. And every time I have to approach a new healthcare provider, I offer to email it to them. I show it to them on my phone, and I offer to email it. And they're usually very, very happy to see that, just so that they have the documentation available.
I think we can cross-reference this document with the form document, but have a separate paragraph that talks about, have all relevant medical forms, supports, powers of attorney, supportive decision-making, and so on, in one place as a PDF on your phone or on a flash drive or whatever, and so that it's always available for use when needed. I think it's a very good addition.
Tom, this is Suzanne. Hi there. Thanks for
Hi.
all your way.
Hi.
I know that you said this is such a rare, if ever, kind of a project, and this is for Missouri, but it's also a national example, and the national links would be helpful to people in Missouri. So if we had a link to the National Disability Network so they could find the PNA in their area, and maybe to like a hospital association, doctors and nurses associations, American Medical Association. I was just thinking, if somebody had a complaint, that they would be able to figure out who they could reference, even if they're outside of Missouri. Can we put national links in here that people in Missouri and other people outside of Missouri could?
Yes, so that is in the reference document in the first paragraph here, which we'll be getting to in a second. The how-to references for patients, families, and providers. If you click on that link and it takes you to the document, it gives you more details about, for example, the Bureau of Hospital Standards and where you would contact them, or the Office of Civil Rights of the Department of Health and Human Services, et cetera. So when we get to that, let's take a look at that and see if that's sufficient, or if we need to add another section that just talks about national resources. And maybe that's the way to do it. At the very end of that reference document, just have a section called national resources, and then we could put a link, for example, to the protection and advocacy website that has them for all the various states, and same thing for adult protective services for all the various states, et cetera. So that would be an easy thing to do.
Thank you.
Okay, let me go back.
One other thing, Tom, do you think it would be helpful to include something that talks about like when medical power of attorney is not appropriate, or kind of the limitations in terms of people's capacity to assign a medical power of attorney, just so people don't end up in situations where it's being denied, or
Yes.
I think that's a very sticky
think-
area for, at least around here, that there's a lot of confusion, and certain, places do it different. So I think it would be good to spell that out.
I think we can spell that out in both the patient how-to and the family how-to. Just to make it clear, if the person has capacity to make medical decisions, you're going to rely on a supported decision-making agreement. You're not going to rely on a power of attorney, because the hospital is not going to accept that if the patient's communicating and seems to have the ability to make decisions, even if it's with assistance. So yeah, I think that would be good to clarify that, maybe emphasize that a little bit, so there isn't.
And I think the other direction as well of people who may not have capacity to assign a medical power of attorney, just so like kind of still acknowledging that perhaps guardianship is appropriate in certain circumstances, and that the limits of somebody's ability to assign a guardian in those cases, Just to, I
So-
feel like it's a lot of confusion of like where that medical power of attorney really is the appropriate choice.
Okay, so I think that it would be adding a paragraph then to the patient document and the family document that on when a guardianship is appropriate for medical decision-making. And just to clarify that sometimes it is necessary because the person, if they're in a coma, obviously, but if they haven't executed if they've executed a power of attorney and they had the capacity to do that at the time, then even if they're in a coma at the time the medical care is needed, you don't need a guardianship, you just rely on the power of attorney. But if they don't have the capacity to execute a power of attorney, then you may need to get a guardianship for medical decision-making because the provider, for serious medical things, the provider is shouldn't be causing problems if we're talking about teeth cleaning or something. But if you're talking about anything that has any potential serious side effects, they have to get informed consent. And informed consent, if the person can't do that, then the supported decision-making agreement doesn't help. And the power of attorney won't help if they don't understand what a power of attorney is or what they're doing. So yeah, I think having something and maybe even a section in the reference materials that goes a little bit more in detail about when a guardianship or a limited guardianship is appropriate. Because if it's only being done for medical purposes, then a limited and maybe even temporary. So I think we can talk about it may be a temporary guardianship or a limited guardianship. I know Will has discussed that at the previous meeting about sometimes, it doesn't have to be a permanent plenary guardianship for all purposes, a temporary guardianship or a limited guardianship just for healthcare or healthcare and finances may be sufficient. So that's a good idea. I'll work on those. And after I put those sections in, which it might take a week or two or so to do that, I'll send it out to everybody so they can see how these issues were dealt with in modifications and give people an opportunity to give feedback as to whether they feel it's sufficient or not. Okay, how to for providers. Okay, so providers we're talking about kind of the flip side of the coin. We're not talking about, well, we're talking about patients' rights, but we're talking about it from the perspective of the provider's obligations. And so this document looks at the sources of those obligations in terms of not only patients' rights, but also their, ethical and legal duties of informed consent and so on, and tries to just have a little checklist here about what we're talking about in terms of adult patients with developmental disabilities and what those obligations are. So, the Americans with Disabilities Act is a biggie. And to some extent, Section 504 of the Rehabilitation Act, even though the obligations are basically the same, although the Rehabilitation Act applies to providers who receive federal funds, and many of them do. I mean, all the hospitals do, and many providers do, but like not all dentists do, et cetera. But Title II applies to healthcare services offered by state and local government entities, and Title III of the ADA applies to private businesses and facilities that provide medical services. So basically, everybody's covered one way or another, whether it's Title II, Title III, or the Rehabilitation Act. And kind of in a nutshell, the obligations come down to three basic components. One is you can't discriminate against people on the basis of their disability. Two, you have to ensure effective communication for the individual in the delivery of services or the receipt of services by that person. And three, that if it's necessary, reasonable accommodations or modifications of policies and procedures must be made to enable the person to have equal participation in the service. In this case, it's medical services, and that's also decision-making is a part of medical services. Unless doing so fundamentally alters the nature of the service or imposes an undue hardship on the providers. So those are the exceptions and the burdens on the provider to establish those exceptions. And then it just talks about in the area. Go ahead. Was that somebody? Or just okay, that was just a glitch. The medical decision-making is a part of the healthcare services. And so, again, accommodations must be offered and effective communication to ensure that the person can either exercise their right of self-determination with some supports and services, if necessary, and that they're not being discriminated against in the process of the delivery of services. So we get into the reasonable accommodation part of it with respect to some specifics here, and that is their right to a support person. There would be no exceptions to that because I mean, I guess if you're talking about you don't have the right to a support person in a surgery room when someone's performing surgery. Okay, so that would fundamentally alter the nature of the procedure to have an unauthorized person in a surgery room. But for most purposes, they have to allow the person to have a support person to assist them throughout the healthcare delivery process. Then the healthcare agent, if the doctor has reasonable cause to believe that the person lacks capacity for a specific medical decision, then they must allow the person who's designated as a healthcare agent through an existing power of attorney to make the decisions for them. And if the person has not been declared incompetent by a court, then the person has the right to make that delegating authority through a power of attorney. Unless the healthcare provider feels that for some reason at the time that the power of attorney was executed, which we're talking about could be weeks or months before the procedure, they would have to have some basis for reasonably believing that the person was subjected to undue influence or for some reason that document was invalid, but they can't just make that up on their own. There has to be some type of evidence. And then in terms of reasonable alternatives, that the refusing to provide medical services without a guardianship would be disability discrimination unless there's evidence that the person is not, if they need informed consent and the person cannot give informed consent and doesn't have a valid healthcare power of attorney, then you have nothing in place a parent can't just come in and give the informed consent. It's either got to be the patient directly, and if that can't be done, and if there is no power of attorney, then we're talking about, then there really is no reasonable alternative other than a guardianship, and a guardianship could be recommended, and that would not constitute disability discrimination. So, and then in terms of their duties for their ethical and legal duties for informed consent, there are statutes on that, federal statutes, state statutes, and ethical obligations regarding providers getting consent before performing a procedure. Obviously, when the patient is a minor, that consent is given by a parent or legal guardian of the minor. The minor can participate in the decision-making process, but the bottom line is the legal authority is with the parent or the guardian. Now, once the person becomes 18 and the medical rights transfer to the patient, then we're talking about the provider has to go directly to the patient to get the consent or the informed consent. And that's where there's two different types of consent: simple consent and informed consent. Simple consent is just simple procedures, teeth cleaning or taking blood pressure or listening to a heartbeat. So the issue of capacity doesn't even really come up there. There's no need for it to come up. And, I guess unless the person's in a coma or something, people can give simple consent with the most minimal amount of capacity because there's no risk involved in the procedure. But when there is risk, then the person's got to weigh the benefits. Well, the provider has a duty to explain the risks and the benefits to the patient, and the patient's got to give consent based on that information that's provided. And if the patient is not able to understand because of the complexity of the risks and benefits, then that's where the even with help through a support person or through a supported decision-making agreement, if they still can't understand and give informed consent for a more serious procedure, that's when the power of attorney kicks in, if there is one. And if not, then that's when the guardianship would be necessary. So then we get into when and how to evaluate capacity. And this is for providers, that it's not an all or nothing proposition, that it's situation specific, procedure specific, or medication specific. And so the capacity, and again, unless the person is so seriously disabled that they can't communicate and they can't understand anything, you have to at least attempt to seek consent from the individual with assistance and so on. And if they're able to do that, fine. If they're not, then you go to the next level of evaluation, and that is, do you have a power of attorney? And going through the power of attorney for that. If they don't have a power of attorney and the preliminary assessment indicates that the person may or probably lacks capacity to give informed consent for this specific procedure, then a more formal evaluation may be necessary. Now, if the patient and the patient's family doesn't agrees with the preliminary assessment of the provider, then there doesn't have to be a more formal evaluation. Probably that's everyone's in agreement. And you're either going to use the power of attorney for healthcare, or you're going to have to seek a guardianship for it. But if there's a disagreement on that, then the patient individually or through their advocate, family member or other, could ask for a more formal evaluation by a qualified professional, and it could be referred to an ethics committee, or it could be referred to a psychiatrist or a psychologist on staff, or who's available to do that. And a more formal process could be used to make that determination. And then a referral to protective services may be in order, sometimes by the agency, because let's say that they feel that something is really serious, needs to be tended to. And if the procedure is not done, there's going to be serious damage, maybe irreparable damage to the person. It may not be a life or death situation. So to that extent, it may not be an emergency, but it may be so serious that irreparable harm could be done. And the patient says, no, I don't want to do it. Or a guardian says, no, I'm not going to give consent or whatever. So if a provider feels it's necessary that this really would amount to self-neglect or medical neglect by a care provider or family member, then they could refer the matter to Adult Protective Services and let them do an investigation and let that run its course. And then explaining to the providers about the public policy on least restrictive alternatives. A lot of them really aren't aware of that. I mean, it's not, the law isn't that old, and it's just a few words put into the state statute about supported decision-making as a less restrictive alternative to guardianship. And it's not really spelled out or defined, and there's no sample of, statutory form for it and so on. So healthcare providers have to be educated about the public policy of the state to only implement guardianship when there's no less restrictive alternative that will suffice to protect the individual from harm. So this just spells out to them that supported decision-making is mentioned in law, that it's authorized. That may be one way for the provider to, let's say, fulfill their obligation, but making sure the person has support and help in making the decision, or by providing other supportive services to the individual, even if there is no agreement in place, to help them make decisions on their own with that type of help. That a durable power of attorney, if it exists, would be a less restrictive alternative that must be used if it's in place and without a guardianship being necessary. And then how the provider can avoid complaints, grievous lawsuits. And basically it's by becoming educated about the rights of the patient, about their own obligations, and what they can and should do to enhance the patient's rights to the greatest extent possible, and making sure that they're really only recommending guardianship when nothing else will really suffice, because it may be necessary. But from some of the data that I've been seeing about Missouri, Missouri is not very good at this in terms of the data about the percentage of adults with developmental disabilities that are being put into guardianships. When you compare it to other states, Missouri is not doing very well. So this is where the providers, the medical, nursing, and dental schools need to be educating the students about the medical rights of this patient population, and including decision-making rights, and really all of the information that's in this document should be part of an educational process for students. And then the healthcare providers, some of the larger ones, or the associations, professional associations, should be incorporating these issues into continuing education programs. And if they don't have the resources to do that themselves, there are a lot of national organizations that have webinars and guidance materials and videos and so on that deal with these issues, deal with this patient population, and help to educate providers, some of whom may not have a large number of patients with developmental disabilities, but if you have one or two or three, you still have an obligation to deal with them in an appropriate and professional way. So, really all providers should be educated. And I think we'll be getting into this more when we get into the meeting about education and continuing education and so on. Also, the providers should be designating someone, a staff person, to be an ADA and 504 coordinator for that particular facility. And state agencies, the Department of Mental Health and the Health and Senior Services should be taking a more proactive role in making sure that providers have all this information and are educating staff, have a 504 or ADA coordinator and so on, and just helping providers as much as possible to meet their obligations. So this is and someone mentioned to me that, well, maybe you should have citations in here, but this is kind of meant to be an easy to read document. And as we get into the next document, all of the statutes and regulations and court cases and other citations are provided for those that, especially the legal-oriented people in the healthcare industry. That's all available for them in that document, and that document is referenced here in the first paragraph. Anyway, it's a lot to say, but that's it. I'm opening it up now.
Tom, on this document, first of all, it's really well thought out and it has a lot of detail, and I appreciate that. In my experience working with healthcare providers and especially clinicians, it's really hard to get them to sit down and focus on this much information all at once.
Right.
And I was just thinking how wonderful it would be, and I know this is really difficult, but if I could have like a one-page handout with maybe some graphics or decision tree or something that I could give them to grab their attention on the key points, then maybe with links to additional info for more information, go to, for example, this document, something like that.
Yeah.
It would give me a quick go-to reference for them to have a high, mile high conversation about their responsibilities as healthcare providers, and then encourage them to reach out for more information through this document.
Yeah, that can be done. I mean, I guess the question would be maybe having somebody look at this from a provider point of view who's pro-patient rights to identify the areas of this that should be put into that. So I think having the eye of a provider to come up with the bullet points would be best. I think it's all here. The other thing that I would suggest is I think that at some point down the road, after we're done with everything with this work group, that it would be great to have a webinar, maybe a 90-minute webinar for healthcare providers that basically goes through all of this. And then that, of course, will be recorded and made available. But I think that, in other words, not just it would be for doctors and nurses and dentists and support staff and everybody, social workers and other people that are involved, to have one or more, because webinars on this, and at least get some key people in the larger institutions well versed on this, so that there's a go-to person for each large organization who knows this more in depth. And it'd be interesting to do a survey of the larger providers to find out who is their ADA person or their 504 coordinator, if they even have one. They probably do in terms of employees and their duties to employees under the ADA. But I don't know, but you know, there should be one go-to person for each larger provider on all of this. So I agree with you about a 1 or 2 page bullet point thing that really brings across to them the highlights, the key points, and they can go deeper if they want. But then I think if we could have the 2 other aspects of a webinar for the people on the front lines who want to take the time to do this, but also to educate at least one key person with each major provider.
I think that's a good idea too, because we're kind of focusing on that, like with the schools too, like in terms of train the trainer and building that capacity that way, and trying to find like some key people in all the regions of Missouri that can be kind of be the go-to people for that. So we could do the same for this too.
I know that our local hospital and some of our medical clinics have what they call lunch and learns. So, you know, a 60-minute session where
Yeah.
people all come together during lunch and just go through the material might be a great structure for that as well.
I also wonder about educating the community health workers that are in those facilities as well, because they should interact with all of the patients that come in.
Lori? You're muted still, Lori.
Yes. I was also wanting to include, you know, a little bullet point flyer for people with disabilities, for people that need this guidance, and a simplified way to present it to people that are going to need it. Not just for medical people,
Yeah, so
but for people who are
that's
going
the
to need
first
it.
that's the first document, how to guidance for patients.
Health
And
advocate.
you may not
I
have
think
been,
you hopped on a little bit late. You
Yeah.
probably missed that part.
however,
That might be.
we talked about
I
making,
also
go ahead.
I would like to suggest that whatever training is done for medical professionals, that people with disabilities are included in that training.
Yeah, absolutely.
I think that it's more effective when it comes from a person that may need those services.
Yeah.
I think the content is-
Advocate.
yeah, definitely. The content is really good. I think the like how the distribution and the how is probably the more difficult component, and I think providers like someone was saying before, a short window of opportunity in like in the context of a given visit to get their attention and get them to read more. So I think it's probably going to end up being a multi-layered thing, like the short 1-pagers, the more robust information, ideally in places where providers go, somewhere like up to date is a resource that like people use at point of care all the time. And then more broad continuing medical education, but how do you know, and trying to find the right people to get involved. And I think that kind of engagement is probably the harder part than the content almost.
Okay, so the next link goes to the longer document that goes into detail. So I'm not going to go into all of the details on all of this, but as you can see, there are sections on, you know, the right to self-determination, various patients' rights, capacity assessments, advanced directives, HIPAA disclosures, supported decision-making, the complaint process, you know, all of these different aspects of medical decision-making. And, you know, starting with the right of the individual to exercise decisions relating to their own healthcare. So, and as you see from this, we've got specific citations to the court case, for example, the Missouri Supreme Court decision on that, and then regulations on medical decision-making by the Department of Mental Health. And when you see where it says excerpts, if you click on that, it takes you to another document with more details. So this document is 17 pages long, but it has everything that lawyers or administrators, for risk managers, others for healthcare providers would need to know that we're not just making this up. You know, we're not just saying this because this is what we would like or what we believe or what should be. This is based on existing court cases, statutes, and regulations. And as much detail as they want, they have it. But at least this document sets it out in an organized way according to topic to give, you know, the basic information on each one of these. And then with a click to a larger document from which these excerpts were taken. And so, you know, it goes on and capacity assessments and so on. The statutes and cases on the capacity to give medical consent. Anyway, so this is, I say, more probably for the administrators, lawyers, risk managers, staff with the professional associations and so on. But it's all there. And at some point, if we ever get the attention of the court-appointed attorneys and the judges that, you know, are involved in the guardianship proceedings, this is the type of a document that could be used for a webinar or for education of those legal people. So anyway, I don't want to take the time to go through all of this, but I do open it up to any comments or questions. But it has all the details that anyone, I think, would reasonably need. Okay, then the final one is just something that I thought, you know, everybody hates forms, but they love forms and they rely on forms. And so I thought it would be good for us to consider some forms that could be used by patients or their support people or anyone involved in the medical decision-making process for many of these aspects of medical decision-making. And I've never seen a form that's called designation of ADA support person. People just say it verbally or whatever. I couldn't even find anything on any websites for hospitals or of like a place to request an accommodation. There's no, it's information on the ADA and the delivery of medical services is just not that obvious on websites or in other places. So here's the link to I just thought, okay, I'm just going to come up with a document. And if someone wants to improve on it, you know, great. But let's not be intimidated by the lack of forms on a subject. Let's just create one and then improve on it. It's kind of similar to what was done in the supported decision-making agreement, that people just started coming up with them and then fine-tuning them and improving on them and so on. So they're all kind of work in progress. So this is just something where the person says, I've got a disability, I want help in the delivery of, you know, in my healthcare services. Here's the name of one or two people that I authorize, and I want them, you know, to help me with these various things. And you can just give that, you know, fill it in, sign it, and, you know, give it to the medical person or put it in your, I guess what some people are calling passport, your passport to medical services PDF document that has everything in it that you might be able to, you might need. So the same thing with a HIPAA release of information and records. So I just found this one that was adapted from something the ACLU had done. And so a person can just say, I want this person to have access to medical information and medical records, either all my records or some of them. And, you know, that's it. So they could use that form. I've seen designation of patient representative is mentioned in a lot of federal documents, mostly in terms of designating someone to deal with healthcare information or records or financial matters related to healthcare and so on. And so I just found this online that someone did and just adapted it. And it may be redundant to the power of attorney for healthcare, but I would rather have too many forms than not enough forms when you walk into a doctor's office. So if they say, oh, you don't need this because you've got a healthcare power of attorney or whatever, but let's cover all the bases. So this designates someone to be the person's representative. And then we've got the designation of the healthcare agent, the power of attorney. Some of the forms are lengthy. They're several pages long. They also include the advanced directives as a part of it, which you can fill out part 1, just naming someone and giving them basic powers, or you can fill out part 1 and part 2, and it's much longer. I found this on the website of the Barnes Jewish Hospital. That was just a 1-pager where you designate someone to be your healthcare agent. So I thought, I like that. I like 1 page. And then you either check yes or no on some of the authorities that the person is giving them. But they don't, even if all they did was put the name of someone in there and signed it, they would just, the patient would just have to know that to have capacity to do this, you just have to know that there are times when a healthcare provider, doctor, dentist, or so on may believe you don't have the ability to make your own decisions. If that happens, then you have the right to, in advance, to select someone who you want to be able to make those decisions for you, and they will have to honor that. All you have to understand is there might be times you might not have the ability to do that. You have the right to designate someone, and this is the document you sign when you want to name that person. Do you understand this? If yes, then you can sign this. And if you want to give them, excuse me, if you want to give them some specific instructions, here they are. I would say that what would be helpful to go along with this one document is a script for in simple language to explain these components. And so that, and that will kind of go along with another document that we're going to get into later on about someone certifying that they believe the patient understood what this form meant. But having a script that would be very simple. Again, the script could even have visuals or whatever, and large type, and whatever, however you want to do it. But I think that and I know that Will said that when protection and advocacy helps someone fill out documents, they go through a significant explanation process to make sure that the person understands what the document is. If they don't, then they're not going to have them sign it. They're not going to be a part of that to go through a sham if they really don't. But simply understanding, there may be times when you can't do this because the doctor says so. You have the right to choose someone. This is the form you do sign. Who do you want? Let's fill this out, and so on. That doesn't take a lot of capacity. A lot of people can do this.
I think Will either has a question or a comment.
We can, if we want to talk about these individually before we go to the end, we can open it up for conversation now.
Well, I just was flagging because I've seen that document so many times, with going into Barnes and Mercy here in St. Louis, I just wanted to flag that sometimes hospitals will have their own document and you just have to ask for it. And there's one that they prefer. And it can be hard to get them to accept another document, even if it's, the exact form specified by the Missouri Bar. So that's just something I wanted to, raise awareness of. But I also think that, as you were saying, just having a document like that, even if it's not that hospital specific one that you're bringing with you, it doesn't take a huge explanation, and it can be very helpful if the hospital is, even trying to figure out what you want and what your desires are.
Yeah, I think that, in other words, if a person knows that they're going to be dealing with a particular hospital and they know that in advance because that's what they've done, it's close to them and so on, then for sure, use their form. But there are times when, you may not know, or you may have moved from you lived in one part of the state, and then you moved to another part of the state. And now that you need the document, you lack capacity to do a power of attorney. So if you lack capacity at the time that it's needed, but you have one that you filled out before that you did understand at the time you did it, I believe it would be disability discrimination and violation of the ADA for a hospital saying, no, you have to use our form, but you can't do it because you lack capacity now, so too bad.
Yeah, and you can keep in your hospital file a record of your powers of attorney that you've previously signed. So in
Yeah.
theory, that's what should happen is they go into your chart, they see, oh, he had a power of attorney in 2017. We don't need to get a new one.
Right. But I do think, if you are using a particular hospital or know you're going to, then, you could fill out their form. I just put this in because it was a one pager. It was so simple, even though it's going to need that, additional explanation to be given to the individual who's signing it. Okay, the complaint regarding the hospital. So this is just the form that is used when if a person has a complaint against the hospital, and I just put it in the packet here. And at some point, I think that it'll be important to educate the people at the Bureau of Hospital Standards about these issues, about medical decision-making issues, and how it would be a violation of various laws or regulations if hospitals don't allow the patient to participate appropriately, and that they may be getting complaints in the future on these issues as patients and their families and other advocates become more educated on these issues. So it'd be good to have them given a heads up and, be given all these materials that we're doing, just saying, just be prepared that some complaints may be coming your way for issues that you may not have dealt with in the past because people didn't know that they could complain to you about that. The healthcare passport idea, this is just a sample that I found online that when someone was mentioning about, having all of your stuff together in one place. So this is the form that is intended to be as easy for the patient as possible to fill out. And, it just has my medications are, when I take them, what I'm allergic to, how I communicate pain, if I have pain or if I get upset and so on. So this or something else would be helpful along with other documents to use. And then I'll just go into this final one and we can open it up to anything and everything. And the other is and I started thinking about this more after I had talked to or communicated with Will about making sure that the individual really understands the documents that they're signing. But I thought it would be helpful in case a provider is, it just might make them have more ease of mind if along with the documents, there was a certification by someone who explained it to them. And the certification says, here's what I explained to them, and here's what their answers were. And based on that, I believe at the time they did that, they understood that document and there was no, coercion or undue influence and so on. So I called it a certificate of understanding and voluntariness of documents. So I just put all of these various documents in there with a check mark or initials or however they want to do it. And this could be, there could be even an addendum or something, a person could add to it other explanations, or they could create their own form, but at least starting with something about some type of a certification that's included in the packet of documents. And I know that, like, for example, with the power of attorney, the law says that if the patient represents to the person, to the healthcare provider, that this is their power of attorney, they can reasonably rely on that, unless there was like some red flag. They're saying, I don't want to do this, or this isn't mine, or somebody forced me to do it, or something like that. But absent evidence to the contrary of involuntariness or so on, the provider can rely on representations made to them that this is their power of attorney, for example. So having someone certify this explanation process and that the patient understood and that this was done voluntarily is just something I think that could be added to the forms. Anyway, so that's all of the components that were, if we're reading in the how-to. And at this point, I think we can just open it up for any additional comments or conversations about any of this or anything.
Do you have any recommended forms for when an individual's in residential services and they have a guardian who has designated that residential service provider to represent that individual in healthcare settings? So more often we have somebody who has, say, for example, a public administrator guardian who is not completely familiar with the individual on their caseload, receiving residential supports, and it's that residential service provider that accompanies that individual to medical appointments and emergency room visits and so forth. They usually have some type of form which may or may not be recognized by healthcare providers.
I think that would be a great thing to add to this, that it would be, guardian designation of healthcare agent or something of that nature that just says that, I'm the individual is under a guardianship, that I am the guardian. And in the event that I'm not available to be present or to give informed consent, I'm designating this person to do that. I don't know, I guess the question would be, is that a delegable authority?
So I can speak to that a little bit as a public administrator. I have to be really careful who I designate that authority to, because oftentimes if you have a provider taking your individual to a doctor's appointment, there may be different staff members in the home that I would be comfortable with their decision making, or it may be somebody who's been on the job for 2 days and doesn't know my individual, and I wouldn't be comfortable. So I'm really careful before I even try to delegate that. Usually I sign something saying if it's an emergency situation and they've tried to reach me and I have not you know, they can't reach me at that moment, certainly go ahead and get that emergency care and then contact me as soon as possible for consent. But I myself in my court, I don't feel comfortable just like a blanket delegation of that role because I don't really know who I'm delegating that to, if that makes sense.
You know, it does. It makes a lot of sense. That's why I was questioning, you know, is that even, you know, something that can be delegated? That obviously the person I guess you could say they can be there as a support person. You can certainly authorize them to be present and to communicate with the patient and the doctor, you know, but not make the ultimate decision about
Exactly,
anything.
right.
Yeah.
Not provide that consent, but certainly to accompany, to provide information on day-to-day, you know, what that person might be experiencing and helping communicate that to the provider is typically where I kind of see the provider's role, but certainly not consenting to procedures.
Right, I would agree with that, you know, and more often than not, it's because the staff are not allowed to be in the emergency room or in the doctor's office, and the individual involved doesn't have any cognitive ability to understand what's happening in those settings, and the guardian's not present physically. And so not so much consent as it is just to be there and facilitate the communication and not have to worry about HIPAA compliance. And I think it's liability and HIPAA compliance that gets them most concerned. So, but we've had some people in some pretty precarious healthcare situations because the staff was not allowed to accompany them into emergency rooms or medical appointments, and improper care was given.
Yeah.
Is that nothing of the pandemic or even after?
No, even recently, for example, we had somebody who was NPO go to the emergency room and with chest pain, and the staff person was not permitted to accompany that individual into the emergency room. And as an emergent precaution, they tried to give this individual an aspirin by mouth while they were doing some diagnostics, and the individual choked. And so had they had that staff person in the room, they could have known that they couldn't do that. I mean, it's all in the records and so forth, but that's not always how it works out in the delivery of the emergency services. Especially our local emergency room has a lot of third-party staffing, outside staffing. And so there's a lot of turnover and not a lot of familiarity with individuals. So we've had multiple situations like that where people were at risk because their support staff were not allowed to be in the room.
Wouldn't that be considered like a reasonable accommodation to have?
Yeah,
I would think.
Yeah, and I think the first form that we had on the forms list of designating ADA support person, the guardian could sign that form authorizing a specific person, and it could be for a specific date or for a specific month or a longer period, but that particular person is authorized by the guardian to be the patient's ADA support person. So that gets them into the room and communicating and helping the person understand. And of course, the benefit to the guardian is also having somebody that can report back to them what happened. Someone who was there and may have more time to communicate that than a doctor or a nurse that, has moved on to so many other patients and all of that. So I think that form could be used, and even if necessary, if the hospital wants to have that support person, have the guardian sign a HIPAA waiver for private medical information, that could be signed for a specific occasion, visit, or time period or whatever. So, yeah.
Couple questions. Are you guys able to see the things that I put in the chat most recently? There were some things, and I wasn't sure if you were able to see it. I had some questions, but the last one was, is it okay for us to share the documents that you're including to us in this project with someone, for instance, if they were going to use it in practice to make a power of attorney or to use supported decision-making agreement? Marie also had a question about this, like some of the information that we're saying the patient has the right to this, that, and the other. Can we share that information?
Yeah, it's all there available. I mean, these are again works in process in progress, but I don't see any problem of you sharing it with anyone you want. It's just it's not legal advice. We're not giving legal advice. It's not intended for a specific case or situation. It's, you know, general educational materials at this point. And but I don't have any problem with you sharing it with anybody.
And thank you. And in the case that you were just talking about, if the person who is the person under guardianship and the guardian or the resident staff says they represent the patient and they actually give a direction to the healthcare provider that is contrary to maybe what is true or what the patient wants, is there anything additional that you would say that that patient could do in terms of a complaint? I mean, they could file a complaint with the hospital of abuse or something, like that the resident staff or the guardian is not doing what's in that person's best interest, or maybe not presenting something that is the truth. Is there something different other than what's on that other how-to patient form that they could, a step they could take?
I think that the depending on who the guardian is, if it's a public guardian, then they have offices and a complaint process that you could go through. If it's a private individual who's the guardian, then someone could notify. I mean, that would really be like malpractice for or a violation of ethics or their duty. You're not acting in the best interests of the protected person if you're giving false information to or misleading information to a medical provider. So, you know, adult protective services, that could be considered medical neglect if you're giving false information. If the person has a professional license or as a guardian, then you could complain to that, you know, supervisor or other authority. And then ultimately, someone could help the patient to write a letter to the judge, to the court, to bring that to the judge's attention. So those really are the remedies for that type of a situation.
And I can email you the things that are in the chat if you're not able to see it. One of the questions I had was about, one of them was about when medical facilities are having people sign a blank screen and you can't see what you're signing. And then I've had my children denied healthcare services because they don't have a formal piece of identification, which often people with disabilities don't. So isn't there an ADA accommodation that would say, well, I don't drive a car, I don't happen to have identification yet, can they refuse healthcare to that person? And I notice even in banks and in hospitals these days, they have assigned a little electronic blank, nothing, just the black screen, and you don't have access to the contract. So then, of course, you can't line it out and say, I don't consent to this, I consent to that, or even to see what you're signing. But that happens in the ER and in the hospital often. I wondered, you may not have time to answer all those questions. I can email them to you now because I know we're in.
Yeah, on that one, I think that it is a matter of asking for a reasonable accommodation. And in terms of like identification, they have to know that who they're dealing with. So if you have some other basis, or you can certify under penalty of perjury. I mean, if you don't have official photo ID and all of that, that's government issued, then you have to provide some alternative to that that would give them assurance that that is the person. And so an affidavit under penalty of perjury saying, you know, I am the parent, or I am this or that, and this is the person, here's their picture. So you would create a document. But I also noticed, I think Marie had a question. Marie, did you have a question?
Yeah, I was wondering if like say you're like it's kind of like about if you're in a facility, like if you're in a facility thing, and you're like asking like say you didn't have any medical like to help you, like say you got like a cast or like a slip on your foot and no one was helping you like with your medical, like you didn't have any medical at the time to pay for a cast or like, you know, a boot or anything like that. But then finally it took so long to get it. So how would you come about that?
So you're saying delayed medical care?
Mm-hmm.
If there's an unreasonable delay in medical care, then I think it's going to be a complaint process afterwards. I mean, when it's happening, when it's actually happening, it's a matter of speaking up and trying to, get some type of help. Obviously, sometimes, it's not a priority if you're in an emergency room and they have all these people that, are bleeding to death and all of that. They're going to place it in an order of priority. But if you never get the medical attention you need, or it's unreasonably delayed, then you can file a complaint. All the providers have a complaint process that you can use.
Okay, so how would you do it if you're there at the Ojai facility and like I guess I could use my support people to help me, but
Yeah,
yeah,
yeah.
it
You
just
just
took
say
a
that
long time.
you have a complaint that you want to file and ask for
Yeah,
the form or forms and have the people help you with it. So it's a matter of sometimes it's not pleasant to
no,
engage in a complaint process. Nobody likes to do that, but that's the way things get improved when people do speak up.
yeah. Thank you.
Okay. So I know a few people had to jump off, and so I guess it's the time to wrap up. If there's any additional questions or comments before we end this.
Well, just thank you so much for all your hard work on this. These are badly needed resources in our field, and I really appreciate you taking the time to work through it all.
You're welcome. I've really been enjoying it. It's quite a challenge, and I'm learning a lot in the process. So, um, it's been my pleasure to do this.
Um, I have one more question.
Go ahead.
Oh, okay. I was wondering, like, I saw like the questions and stuff like that. Like, I was wondering if you could do like plain language, like pictures for some people with disabilities, so some of them can understand it a little bit better because they can't read.
Yeah, yeah. I think that I would like to see some of these documents. Um, First of all, we want to simplify it. We want to add some visuals. We may want to do it in an audio format as well, so people can listen to it and it can be said, slowly and understandably. So you get, a variety of different formats. So that's the next stage down the road when the work group is over and we make recommendations. We'll include recommendations like you just made
Yeah,
in the recommendations at the end in our report. And then it's going to be up to others in the state, organizations, advocates, agencies, and so on, to take it to the next level and to take this material and make it user-friendly. And regardless of who the user is, whether it's the patient or the family or the providers. So this will all be transformed into
yeah,
more user-friendly formats.
that's good.
Yeah, okay, great. So then, and I think we'll also have Emily send out another survey. It seems like the last week in the month. The next one may be March 26th or thereabouts. So we'll give like 3 options and try and pick the one that has the most people. The and as I mentioned, the agenda for, let's see here. for the March meeting, it's dealing with the transition from youth to adulthood. And there's already reading materials online, so I've been trying to get these things done well in advance. One of them is resources. And so there's resources for patients, families, and providers, and with links to things that are available online. And then I just completed yesterday an 8-page commentary about how medical decision-making rights should be included in the IEP process by schools and the ISP process by disability service providers, that transition planning is already being done in those two processes. But from what I see, the medical area is not being adequately addressed and dealt with in those processes. So this talks about how that could be improved. So anyway, that's the focus for the March meeting. And with that, I'll stop sharing. And is there any last comment? Okay.
Thank you for all you're doing.
Okay, you're welcome, and look forward to us just, keep going on this until we get through it all. And I think that something good will come out of it, and we'll just keep, improving the situation in Missouri. And I think while we're doing this, we're also creating a template or a potential model that can be used in other states. So I'm going to end the recording. Let's see.